judge presiding, all persons having business before this court, on your due attention you shall be heard. The Constitution of America State of Florida and this honorable court. You can see it.
Good morning, everyone, and welcome to a session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Orfinger, and to my left is Judge Torpy. We have 3 civil cases on the docket this morning, so we've got 20 minutes per side for each of the cases. For those of you who are not familiar with it, we have a clock on the podium, and that'll help you keep your time. If you need an extra eye for rebuttal time, let me know, and I'll be happy to try and help out. We'll take the cases in order, and as apparently counsel for the first case is raring to go, so we'll.
She assumed we were going to go in order.
So we'll call that case the Sheriff of Seminole County versus Oliver, and counsel can begin when you're ready.
Good morning, Your Honors. May it please the Court, April Kirschman on behalf of the Sheriff of Seminole County. This is a civil forfeiture case, and the appeal stems from 2 rulings made by the trial court at the adversarial preliminary hearing stage of the proceeding. The first ruling was that the sheriff failed to establish probable cause that the property was an instrumentality of the offense or otherwise subject to the act. And the second ruling being that...
No, it's got to be either an instrumentality or the proceeds from an instrumentality, right?
Yes, Your Honor, and our position all along is that it is proceeds. You'll recall the back...
Supposing the guy, let me ask you this, supposing this guy worked for this charitable organization.
Correct.
Instead of taking the money in the form of checks, he went into the company's safe and took cash, okay? And then he went and bought the widgets with the cash. Would that be forfeit? Would the widgets be subject to forfeiture?
Yes, the widgets would be the proceeds, and the cash itself would be the evidence.
Well, but no, you said evidence, okay? Mm-hmm. I want you to tell me whether how it's an instrument of the crime.
For forfeiture or for evidence? For purposes of...
In order for it to be forfeitable...
Yes.
It has to either be used as an instrument of the crime.
Correct.
Or it has to be the spin-off, the proceeds from the instrument of the crime.
Correct.
I mean, the classic example would be drugs, which are a contraband article, and if they're sold and there's cash, in exchange for the drugs, the cash is the proceeds of the sale of the contraband article. So I want you to tell me how the money that was stolen is the instrument of the crime of theft.
The money stolen in your hypothetical or the instruments that were used in our case?
Let's stick with my hypothetical for the...
Okay. In your hypothetical, the money itself, let's assume that we could put our hands on that money. If we could...
The thief did. He got it out of the safe. That was my hypothetical. Okay.
And if it's gone, whatever he purchases with that money is proceeds of the illegal activity.
Okay. Now, but the statute doesn't say that proceeds of illegal activity. The statute says proceeds of a violation of the act, right?
Correct,
and the enumerated violations of the Act are possession of a contraband article, concealment of a contraband article, blah, blah, blah. It all stems from the contraband article and the statutory definition, right?
Correct. And the article...
In order for money to be a contraband article under the definition, the money has to be used in connection with a felony.
Yes.
As an instrumentality.
Yep.
Right? That's what I want you to focus on. You keep changing the definition. How is the money in my hypothetical used as an instrumentality?
Well, as we explained in the brief, the money in your hypothetical and the negotiable instruments in ours, being the bank statement that came out and was deposited into another account, when you take that negotiable instrument, whether it's money or in our case the checks, and you use that as an instrumentality to put that money into your own account, the account of the thieves, so that then it's available to you to purchase proceeds from your illegal crime, it falls within the Act and it becomes contraband.
What is the definition of instrumentality?
Well, there's two places that the statute differentiates instrumentality and proceeds. The first place is in 932-702. The legislature created a separate section, which is Section 5, that says to acquire real or personal property by the use of proceeds obtained in violation of the Florida Contraband Forfeiture Act. In that place, the legislature specifically separated proceeds from number 4 above it, which was instrumentality. And they did it again in 932-701, subsection 5. And that says any personal property, and then it goes through a litany of things: money, devices, weapons, negotiable instruments, currency, which was used as an instrumentality or which is acquired by proceeds obtained as a result of a violation of the Act. So it's our position that you can take the more circuitous analysis of using the negotiable instruments as an instrumentality.
You still haven't answered my question about the money, okay?
It isn't.
Is money, in my hypothetical, which was the fruit of the crime, right? I mean, in my hypothetical, it's the fruit of the crime.
Yes.
How is that the instrument of the same crime?
Because it's the only way that you could obtain the proceeds. You can't get it any other way but converting that money into something else. If that person in your hypothetical only took the money and didn't do anything with it.
In my hypothetical, the person took the money and bought the widgets. Okay, you know what a widget is, right? Bought the computer equipment and all the camera stuff and all the stuff we're talking about here. Instead of using the check, just took cash out of the safe and bought it. Let's say you caught the thief while you're standing at Walmart buying the stuff. Can you forfeit the money under that hypothetical?
We would forfeit the widgets.
Well, before he buys the widgets, okay, he's stolen the money. He's got it in his pocket.
Yes.
You caught him walking down the street
Yes.
with a load of cash in his pocket. Can you forfeit the money?
Could we? Yes. Would we? No, we'd return it to the victim. We'd have it returned to the victim as evidence.
Okay, I understand that you might you might want to do the right thing, but the question is, I think your position is that you could, right?
Yes.
And that the trial judge would be in error if he denied your probable cause application, right?
The trial judge in the civil forfeiture, correct.
Okay, so in order for that money, though, to be forfeitable under this statute, it has to be a contraband article as defined, right?
Yes.
And the only way it can be a contraband article is if it was used as an instrumentality in that theft, right?
Yes.
So you're
Or
saying that
otherwise.
any property that is stolen during if somebody breaks into my house and steals my television is an instrumentality of the crime of theft of my television, right?
No, I disagree. That is not an instrumentality. Just like vehicles aren't always instrumentalities in a drug offense.
Well, under subsection 5,
Yes.
it basically includes any kind of object, tool, money, negotiable instruments, all that stuff, right?
Yes.
How is the money, why is the money an instrumentality of the crime of stealing the money, and a television not an instrumentality of the crime of stealing a television?
The instrumentality of stealing a television, let's say out of a residence, might be the car you used to drive to the residence to commit the burglary.
I'm with you, the screwdriver that you used to pry the door open.
Exactly. But not the gain from the theft or the
Okay.
burglary itself.
Okay.
It's only once the item stolen is then used in some manner to benefit the thief or the fraud or whoever it is. When it's reappropriated based upon a criminal act, it is contraband.
So back to my hypothetical about the money, if he's caught before he buys the widgets, then apparently you concede that that is not forfeitable. that money is the fruit of the crime, and it is not an instrument of the crime, right?
Not as long as he didn't buy the widgets.
Okay, all right, so let's get to the widgets then. The second part of the definition says if they acquire proceeds as a result of a violation of the Florida Contraband Forfeiture Act, right?
Yes.
Okay, the only place in here that I find any violations are in 932-702 and all of the subparagraphs, right?
Yes.
Okay, so we know that what we're talking about is a contraband article, proceeds from a contraband article, right?
Well, the proceeds are the contraband article.
But it's got to be proceeds from a contraband article.
From criminal activity.
Well, it doesn't, see, this doesn't say proceeds from criminal activity. It says proceeds from a violation of the Florida Contraband Forfeiture Act, and then you go over to 932-702 to look at what the violations of the Act are, right?
Well, that's one place that it outlines it. But if you're strictly asking about criminal activity, in subsection 5 of the 701 section, it says in the commission or in aiding in the commission of any felony, whether or not comprising an element of the felony. So that, to me, indicates that the legislature was going to consider felonies and as the criminal activity from which the unlawful activity stems.
Well, the
I don't really
proceeds-
quarrel with that. Maybe we ought to just ask you straight out, what is, under this scheme, a violation of the Florida Contraband Forfeiture Act?
Criminal activity.
Any criminal activity.
Any criminal activity could result in.
I know it could, but
Correct.
But it doesn't unless
It doesn't always.
As in Judge Torpy's example, if somebody just steals money,
Correct.
that's not a violation of
No.
the Florida Contraband Act.
No, it would not be. That currency would not be. And if I may, the reason for
So it's only certain criminal activity.
it could be all criminal activity, but it depends what stems from it. And if I may, I think I can explain it through the second part of my argument, which is really the purpose of the appeal in terms of the second part of the court's ruling. And that is that on the one hand, the court found that the sheriff didn't have probable cause to seize this property and therefore shouldn't have it. And yet, on the other hand, directed us to keep it, to keep the items that we seized through warrants, so that the criminal court could determine whether the defendant, the thief, should be able to use the ill-gotten gains towards his restitution. Okay? And so the second part of this ruling is the broader proposition that I'd like to address with the court, because it's our view that this property, ill-gotten gains from this scheme to defraud or embezzlement or whatever you want to call it, is not evidence in the criminal case. This property sits before you in legal limbo. It is not the property of the victim. The victim had money stolen, not iPads and firearms, money. And the defendant, the thief, although I was willing to stipulate that he was a person entitled to notice for the preliminary hearing because he was in possession of the property, he is not a claimant because he can't establish an ownership interest in property that he stole. So
Why doesn't the property belong to the person whose money was stolen?
because I would agree with you under the hypothetical of the money, that would go back. But let's take, for example, a thief who goes into a home and steals $20,000 in cash. And with the $20,000 in cash, he purchases a vehicle. Would we give the vehicle to that homeowner who had his $20,000 stolen?
It seems to me like a classic resulting trust.
Well, that may be, but who's going to adjudicate that? I would submit to you that the
If the
property...
person who had the $20,000 stolen
Yes.
wishes to have the vehicle, all he does is file suit in civil court to recover the vehicle under a resulting trust theory.
But the vehicle wouldn't be recoverable because according to this court order, the sheriff would have had no reason to
I'm not
seize
worried
it.
about this court order. I'm worried about what the law is.
Okay, well, there is
And so our problem is that we're having trouble with the sheriff's premise.
Well, the premise is that there has to be some mechanism to deal with this property that is proceeds. And the proper mechanism is not the criminal court because it's not evidence. And there is, the mechanism that's in place in Florida is a forfeiture proceeding.
To what extent, if any, was the charity from whom the money was originally stolen given notice or entitled to notice in the forfeiture proceeding?
Our position is that the charity is not entitled to notice because they are not a person entitled to notice under the first part of the statute because they weren't in possession of the property and they didn't own that property. And they're not a claimant because if you're a claimant, you must establish your claim pre-forfeiture. And they don't own this property. This property is in limbo. It's not the victims and it's not the thieves. And so the only way to adjudicate this property is through a forfeiture proceeding. And much the same way...
So, but you're saying that if the charity came in, asserted a claim and said, in the forfeiture proceeding and said that we're entitled to this under the resulting trust theory that Judge Griffin has put out there, that you would fight that and say, no, you're not entitled to that. There's no legal basis for that.
They are not a claimant as claimant is defined in the forfeiture statutes. Now, could they get that by virtue of, say, a replevin? Maybe. If they got ownership through some resulting...
They have to have some ownership interest to be able to replevy it. So if they have
they'd
an
have to
ownership
establish
interest,
that first.
Right. So if they have an ownership interest in it, then to enable them to replevy it, then it seems to me they would have an ownership interest in it, at least to be able to participate in the forfeiture proceeding.
Maybe if I answer this way, it will...
Isn't it a basic rule of property law that a thief can never pass good title? Okay. So if the thief never had title to this property because he stole it, as between the sheriff and the charity, explain to me any principle of property law that gives the sheriff, in this case, a superior property right.
Well, the body of forfeiture law. And the reason why is because...
Isn't a premise of the forfeiture statute to protect innocent victims?
No, it's a deterrent to crime. That's the purpose of the forfeiture statute.
It says you're supposed to protect innocent victims.
Through the deterrence of crime.
It says, I'll quote to you, it says, to prevent use of contraband articles for criminal purposes while protecting the proprietary interests of innocent owners. That's the duty that the sheriff has.
We do. And we use the forfeiture statutes as deterrent for those kind of crimes. But as far as the victim's concerned... You
were going to give these widgets back to the victim here, right? You had a charitable motive here.
Correct. Under the unique facts of this case, this charity happened to qualify under 7055 as a place that the sheriff is allowed to redistribute the proceeds.
But what you're suggesting to me, and let me see if I understand this. Thief breaks into my house and takes my television. If you recover the television, I get it back as the crime victim, right?
Yes.
Okay.
Through the criminal case.
Right. Even if he utilizes that item by watching the Super Bowl on it, right?
Yep.
Now, but if he then takes that TV down to trade it for crack, and you recover it as he's buying the crack, it changes hands, and you arrest him and the crack dealer, him because he's got crack in his possession, the other guy because he just, sold him crack, and the currency was my television.
Yes.
I have now lost any right to recover that television.
No, you would not in that situation because we have recovered the evidence of the crime.
Well,
however,
it was also, under your theory, it was also the proceeds of a crime. I mean, no different than the money. It was just happened to be the currency that was used to facilitate this new independent criminal transaction.
But the difference between your hypothetical and where we are in this case is if in your hypothetical,
I just want you to answer my hypothetical.
It was only the crack that we were left with. Our position would be that we're not giving back to the victim.
He
That
traded it
isn't
for
what
a
was stolen.
hammer drill. He took it to the pawn shop and traded it for a hammer drill. Okay, now we don't have the problem with
Of contraband.
contraband, right? So now the pawn shop's got the TV, and the proceeds of it are the hammer drill.
Okay.
The sheriff gets to keep the hammer drill, right?
Correct. The proper proceeding would be forfeiture. Now, are we going to do that for a $50 hammer drill? No.
So
But
we should just trust y'all to do the right thing then.
well, I mean,
We'll make sure that innocent victims of valuable property get the short end of the stick, but if you get insignificant property, we're not going to worry about it. I mean,
no, but I don't think the
I
criminal
gotta tell you,
court
ma'am,
is.
your argument just doesn't pass the smell test on this one, for me anyway. I mean, it just doesn't make sense.
But the purpose for the victim to be made whole is, in the criminal case at least, is through restitution. Oliver should not benefit by not having to make restitution to the
I
victim.
would much rather have the hammer drill than have an order for restitution from some guy who's doing 5 to 10 in the local prison.
And in that hypothetical, then that hammer drill could be ordered that way by the criminal court. But what I'm trying to
Not if
avoid.
the sheriff's got a right to forfeit it.
Well, if they have a right to forfeit it, that doesn't mean they do forfeit it,
Well,
or that after a
They
forfeiture.
either have a right or they don't. We're not going to trust the sheriff to always do the right thing. We've got to follow the law here. So either they have a right, if they have the right to forfeit it, then they have a right to withhold giving it to the victim, and they have the right to sell it or dispose of it or do whatever they want to do with it, right?
Yes.
Yeah, I mean, just like the stuff here, if the sheriff had the right to forfeit all this stuff, he might have a charitable motive in this particular case, but he could also keep all this stuff and sell it, right?
That's true.
Buy more
So if I
tasers.
had been the victim, if the same thing had happened to me, in other words, in my law office, an employee had done exactly the same thing, I just didn't happen to be a charity.
Yes.
You're saying that the sheriff, because I'm not a charity, the sheriff wouldn't be able to donate the property back to me, so I'd just be out of luck, basically. I could not, the thief who stole from me has gone off to prison, and I've got a civil judgment for restitution. All the goodies now are in the sheriff's hands, and you're buying squad cars with it, or, whatever it is you all do with it, and that's just the end of the story.
Well, I'm saying it's a better alternative for the public to benefit at large than for the thief to benefit from his ill-gotten gains.
And you base that on the notion that under the statute, the victim is never a claimant.
There are scenarios where the victim could be a claimant, but since this was proceeds, the victim didn't have an opportunity at the time of forfeiture to establish any kind of ownership interest in this property, a gun and an iPad and cameras and all that sort of thing. So,
Even when it's directly traceable.
I'm sorry?
Even when it's directly traceable.
When this property is not directly traceable to this victim. It is
It
proceeds.
is. The thief admitted that he bought it with, you wouldn't have been able to forfeit if he had admitted that he bought it with the ill-gotten gains, right?
But this property is not owned or possessed by the victim. The victim's property that was stolen was money,
I think you
essentially.
misunderstood Judge Orfinger's question.
Well, and I also, I didn't go back and look at it because I just assumed what I knew from the law, but let me just suggest to you that you might want to go read up a little bit on the law of resulting trusts. Because when I used to handle embezzlement cases, the victim always had a right to go recover the proceeds. When the money had been stolen and somebody went out and bought a house, they had a right to
But
the proceeds.
wouldn't that bolster the court's position that if it were to go through the forfeiture proceeding, that the victim would establish their claim that way and would then benefit from it? Because all I'm saying is that
Saying
the
they're not
legal
entitled-
mechanism is forfeiture.
You're saying that they're not even entitled to notice. So how do they know that they can come in and
Well-
perfect their claim?
Well, that's not to say that they couldn't be a claimant. I mean, the victim is aware of this proceeding because they're a victim in the criminal case.
Okay, We'll look at it. Thank you very much for your argument.
Thank you.
Next case